Hello, my name is Terrell Hussein and welcome to No Opinion. We've got a really interesting document here from the Supreme Court of Georgia. We're going to try to read this in the tone that I think it was intended to be read. Supreme Court of Georgia, case number S23-01134, July 17th, 2023. Honorable Supreme Court met pursuant to adjournment. The following order was passed. President Donald J. Trump versus Fani Willis. Petitioner Donald Trump filed directly in this court an original petition for writs of mandamus and prohibition against Fani Willis, who is the Fulton County District Attorney, and Robert McBurley, who is the Fulton County Supreme Court Judge assigned to supervise and assist a special purpose grand jury that petitioner asserts was impaneled pursuant to OCGA 15-12-101 to investigate facts and circumstances relating directly or indirectly to possible attempts to disrupt the lawful administration of the 2020 elections in the state of Georgia. Herein, the special purpose grand jury. In his original petition, petitioner seeks 1. To compel Judge McBurley to squash the special purpose grand jury's report and to bar use of its content in any future proceedings, whether civil or criminal, to prohibit District Attorney Willis from introducing to the regular grand jury any evidence obtained via the special purpose grand jury, and 3, to compel District Attorney Willis's disqualification as a party representative in any proceedings involving petitioner. Petitioner contends that such extraordinary relief is necessary in this case because, according to him, the entire special purpose grand jury scheme in Georgia is so vague that it violates his constitutional rights to due process under the law, both facially and as applied in this case, because all of the evidence obtained by the special purpose grand jury is therefore unlawful, because District Attorney Willis, who he maintains is operating under a conflict of interest as to him, has signaled her intent to use the special purpose grand jury's report and the unlawful evidence obtained by the special purpose grand jury to secure from a regular grand jury criminal indictments. Because the return of those criminal indictments could be imminent, since the Superior Court judge recently seated and sworn in the regular grand jurors, because the regular grand jury might simply uncritically ratify the special purpose grand jury's finding, rather than take its duties seriously, because the criminal process in Georgia, through which he ordinarily would be required to pursue relief, can be ponderously slow, and because petitioner seeks his party's nomination for the presidency of the United States of America in 2024, such that he would suffer irremediable reputational harm. The petitioner seeks his party's nomination for the presidency of the United States of America in 2024, such that he would suffer irremediable and reputational harm were he to be forced to defend via the regular channels an indictment which he contends would be based on unlawful evidence. Petitioner recognizes that the preferred course for obtaining extraordinary relief is to petition for it in the Superior Court and appeal from any adverse decision entered thereon. See Brown v. Johnson, and states that in an abundance of caution and contemporaneously with his filing of this original petition, he has filed a similar petition in the Superior Court, but he argues that the preferred course is not adequate or appropriate here, and contends that this court should step in and allow him to circumvent the regular judicial process as a way to ensure the prosecutors and courts are not short-circuiting the procedural protections grand juries are meant to provide. It is true that this court has the authority to grant original relief in the nature of mandamus and prohibition. CGA Constitution of 1983, Article 6, Section 1, Paragraph 4. But this court has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely rare situations where need has been shown. See Graham v. Cavender, KC Canada Incorporated v. Head. And the court has made clear that a petitioner cannot invoke this court's original jurisdiction as a way to circumvent the ordinary channels for obtaining the relief he seeks, without making some showing that he is being prevented fair access to those ordinary channels. See Gay v. Owens, original jurisdiction exercised only in extremely rare cases. Brown v. Johnson, 1983, same. Kitchens v. State. Supreme Court is a court for the correction of errors of law committed in the trial court. Petitioner's claim falls in the light of that precedent. Petitioner's claim fails in the light of that precedent. He makes no showing that he has been prevented fair access to the ordinary channels. Notably, petitioner does not assert that the Superior Court has denied him the opportunity or ability to seek therein the relief he now requests from this court. Indeed, he admits that in March 2023, he submitted and the Superior Court clerk filed motions in which he sought to quash the special purpose grand jury's report to disqualify Willis. And although he complains that Judge McBurry has yet to rule on those motions, he is not asking the court to compel Judge McBurry to rule. Instead, he is asking the court to step in and itself decide the motion currently pending in the Superior Court. This is not the sort of relief that this court affords, at least absent extraordinary circumstances that petitioner has not shown are present here. Moreover, even if the petitioner was procedurally appropriate, petitioner has not shown that he would be entitled to the relief he seeks. An initial matter, either in Ray Floyd County Grand Jury presentments for May term 1996, nor Harris v. Edmonds, which are cited by petitioner in support to quash as an appropriate remedy, here applies to these facts. Those cases address situations in which a regular grand jury included in its presentments to the Superior Court and therefore published in a public way a report charging or casting reflections of misconduct in office upon a public officer or impugning his character, but without including a presentment or a true bill of indictment charging that official with a specific offense against the state. And while those cases hold that the subjects of such extrajudicial report are entitled to have those reports expunged from the official record, neither suggests that it is appropriate to quash the special purpose grand jury report based on allegations similar to those that petitioner makes here. Furthermore, this court has held that even where the defendant had established that a special purpose grand jury acted illegally, neither dismissal or the subsequent indictment nor suppression of the evidence was the proper remedy for the grand jury's overreach, because no violation of defendant's constitutional rights, no structural defect in the grand jury process occurred. See State v. Lample. Indeed, in Lampo, we held that grand juries, unlike petite juries, are authorized to consider evidence without regard to its eventual admissibility at trial. Also see Mitchell v. State. The evidence which the grand jury receives in findings a true bill is not subject to inquiry. Citation and punctuation omitted. And with regard to petitioner's request to disqualify Willis from representing any party in any and all proceedings involving him, we note only that petitioner has not presented in his original petition either the facts or the law necessary to mandate Willis's disqualification by this court. Time on this record. For these additional reasons, petitioner has not shown that this case presents one of those extremely rare circumstances in which this court's original jurisdiction should be invoked, and therefore the petition is dismissed. All the justices concur. Supreme Court of the State of Georgia, Clerk's Office, Atlanta. I certify that the above is a true extract from the minutes of the Supreme Court of Georgia. Witness my signature and the seal of said court hereto affixed, the day and year last written above. Clerk. So there you have it. Please like and subscribe. And if you like this content, just hang on, because more is coming. And again, I'll just be reading it with no opinion and no commentary. Thank you for watching.